Good afternoon, everyone. It's my pleasure to be here today. I hope you and your families are keeping safe and healthy. I would like to thank Legal Era for organizing this conference and this session. I'm also honored to be moderating this August panel today, each of whom are stalwarts in their respective fields. And I'm sure we will all learn a lot from their valuable insights they will share with us today. As you all know, the distressed investment market has seen a huge surge since IBC became effective in December 2016. Since then, debts of more than 350 companies have been successfully resolved under the IBC. The IBC has almost doubled the recovery rates for creditors from the pre-IBC era, and has also shortened recovery timeframes by about 60 to 70%. While a lot of focus has been on recovery rates for banks and the timelines for recovery, what is equally important is to see the social and humanitarian impact that this new law has had. So more than 350 companies have been saved from an untimely death. This means that compared to the earlier regime where, in a winding up or a liquidation, it would have meant a total shutdown of the operations. So many employees in these companies will now continue to have jobs. They will be able to earn their livelihood. Many of the allied industries and businesses who are dependent on these companies will continue to benefit, in the long term. And once these companies turn around, they again will add to the economic growth of the sector and the country. So that is indeed remarkable. When the IBC was introduced in 2016, banks and financial institutions were reeling under a huge burden of NPAs. And this was an opportune moment for several asset reconstruction companies who were able to buy these NPAs and thereby freeing up capital for the banks. The ARCs also partnered with and received investments from several domestic as well as foreign investors. And as a result of that, several institutional investors were also able to participate in the distressed debt market in India. In addition, we've had RBI's restructuring scheme under the June 7th, 2019 circular, which has also piqued the interest of several investors, and debts of quite a few companies have been successfully restructured under that framework. However, as we all know, there have been certain events that have taken place in the last couple of years, which has increased the stress on debt in India. Firstly, several NBFCs have gone through a very difficult phase in the last few years, starting with the IL&FS crisis. Thereafter, COVID-19 shocked and shook the world. Several businesses globally and in India have suffered tremendously because of the lockdowns, which were mandated by the pandemic. As a result, I was reading somewhere that the overall stress in the Indian financial system may be north of $150–160 billion today. While a large chunk of this is probably stress in the corporate debt space, the pandemic has also increased the stress in the retail debt market. So on the flip side, both of these could actually provide several opportunities for a variety of investors. Investors can participate, as you know, in the debt distressed market through investing in ARCs, AIFs. Foreign investors can directly invest through the FPI route, and investors can also set up or invest in NBFCs, which are lending to companies directly. In the wake of COVID-19, the RBI had introduced a special debt restructuring framework for companies which were impacted by COVID. The government also introduced the pre-packaged insolvency regime recently to resolve stress amongst the MSME sector. The government is also in the process of setting up a national ARC with the idea of lightening the NPA load for banks. And the government and the regulators are considering various other options to improve the insolvency regime. They're also considering a distressed debt platform. So all of these changes are only going to boost investments in the distressed debt sector. With that introduction, I wanted to jump into asking our panelists their views on the distressed debt market and the investment opportunities and challenges. My first question would be to Mr. Bansal and Mr. Sachdeva. We know that there are several opportunities available for distressed debt investors post the pandemic. In your experience, what have been the practical challenges that you have faced in resolution of these stressed assets post the pandemic? And also, in your view, do you think that the behavior of the lenders, the borrowers, and the investors has changed post the pandemic when looking at distressed investments? And if so, what are some of the changes that you have observed? Maybe if we can start with Mr. Bansal first and then move on to Mr. Sachdeva.
Yeah, good afternoon and thanks for allowing me to be on this panel. So distress asset space, it has its own peculiarities how it works. Now, pandemic has only added to the problem. So I will not differentiate first between the two stages. We have seen typically banks sell the assets sometime very late to ARCs or to other investors till the time 4 or 5 years are gone. So the asset keeps on getting depreciated, losing its value, and that becomes difficult to find a strategic investor. In IBC itself, we have seen in the first round of 12 cases, which started, let's say, in 2017. Today we are in 2021, 4 years. Some of them are still not resolved even today, including MTech, including land codes and the liquidation, APG shipyard or whatever. And 1 or 2 cases, though technically implemented, but not finally started even today. JP Infratech is another example, Restructuring, whatever. So if you see where we could get resolution, where the asset value was good, and sometimes luckily we caught the good cycle. So like say out of 12, 5 were steel cases. So 5 got reasonably good value, though the price is different. One got 92%, second got 75%, third got 55%, fourth got 45%, and fifth got only 26%. And within steel, by the way, all 5 steel companies. So it depends how much that you have, what is the value of the asset. Other than steel, hardly any case is attracted. And one cement case which was not part of 12, Nani Cement, that attracted and we got the maximum recovery in that case. So coming back to your question, whether pandemic has made a difference. So first my point I wanted to highlight, the difference is basically in the value of the asset. And whether pandemic or not, the pandemic has added to the problems of a particular few industries, where it is like say hotel, real estate, EPC companies, and some of the relevant industries where pandemic has more impact. So there the value is much less. Today, let's say just to take an example, before pandemic, we were about to sell a hotel in 400 crore. Today, I am not getting 200 crore also for the same property. So it depends on the industry. Some industry are reasonably doing today. So there is a better valuation in textile today as compared to before pandemic. There is a better valuation for steel in steel industry. It is better than even before pandemic. So it depends on the industry cycle. Perhaps pandemic has impacted a few industries, but otherwise distress cycle, life cycle will behave the way it was behaving earlier also. I will stop at that for the time being. Let Mr. Sachdeva add, because he is the buyer.
Thank you. Mr. Sachdeva, your views, please.
Thank you, Mr. Bansal. I think it was quite insightful. I tend to agree with you, whether pandemic or not, the stressed assets have been facing this issue, and we acquired one of the stressed assets which was acquired much before the pandemic started. But looking at the situation, while the government had announced policy suspension of IBC and no, nothing will be done under the IBC, no stressed asset will be touched upon. We faced a very peculiar issues, and those were continuing even post-pandemic. Our resolution plan, and it clearly provided any liabilities prior to the prior from the date of the acquisition of the stressed asset will not be something which will be borne by the resolution applicant, successful resolution applicant, which we were. And those were to be, either those were not applicable. Time and again, the government authorities, the tax authorities, they started raising demands. Even post-pandemic also those demands were continued to be raised against the stressed asset. Our fallback was always, resolution plan, and we were saying section 31, section 238, that once the resolution plan has been approved, it is binding on all the stakeholders, which means past liabilities for the past period before we acquired the stressed asset will no longer be binding on the company itself. But notwithstanding the fact that those representations were made to the authorities, the demands were coming in. Finally, we had no choice but to approach the high courts and take a stay order. It is not relating to one tax authority, it is a couple of authorities, electricity board, and those problems we face post acquisition of the stressed asset. Now, issue here is, if you are today making an investment, post pandemic, there were a couple of issues which were faced by the industry. At least post pandemic, those issues could be, somewhere while the matters were pending, but we were continuing to receive those demand notices even for the past period. So while government was keen, suspension of IBC should be there and there should not be any further stress on the assets, etc. But the assets which were acquired by the successful resolution applicants, at least for that also some provision should have been made by saying, look, while the matters are pending before the High Court, no such demand should be raised, but that was not there. Those demands continued to be raised against the company, and resultantly we were to go and approach the High Court. That's the first part, I will say, from the practical perspective. While we will say the section 31, section 238, SR judgment, there are a number of catena of decisions, there are a number of decisions by Supreme Court and various high courts where they said the demand for the past period cannot be enforced. Once in the resolution plan, it has been clearly stated or mentioned that those demands are no longer tenable or will not be binding on the company post acquisition by the successful resolution applicant. Having said that, we were forced to approach the high courts and take a stay order against those demands which were being raised. That's the first aspect, which is a practical aspect. I'm sharing it on this platform. Second, now, which Mr. Bansal touched upon, suspension of IBC, and I think this has been a discussion point. When you said during the pandemic there was suspension of IBC, what it led to? It has been, I think there is a loss of value of the asset. The primary objective of the IBC has been there should be a timely resolution of the stressed asset, and this is not only in the interest of the creditors, but it is also beneficial for the borrowers as well. But having said that, I think Mr. Bansal touched upon there was an asset which was valued at 400 crores and now they are not even getting 200 crores. So what it lead to? What it has been there. So suspension of IBC period, IBC proceedings or IBC aspect during the pandemic, finally there has been a loss of the value of the asset. I think that's my take. But looking from the perspective whether it helped the stressed asset or whether there was an accrual of value, according to me, there was a depreciation of value in certain assets, like you see the airlines, you see the hotel industry. If they were stressed, they became more stressed because of the IBC suspension. And that's what is my view about the issue which you raised, Aashit, in this.
Thank you, Mr. Sachdeva. Thank you, Mr. Bansal. I guess the takeaway really is that there have been stresses during the pandemic. Certain industries have suffered more given the way the pandemic has panned out, such as the real estate industry, hotel industry, aviation, airlines. Some industries may have done better, like Mr. Bansal said, for example, the steel industry. And I guess one other issue which continues to bother a lot of the resolution applicants is that post the CIRP completion, the governments and authorities still continue to chase them for demands, even though courts have repeatedly laid down that after the CIRP is over, all the previous claims get extinguished. So I guess these are a couple of issues which hopefully we should try and resolve, at least the issue around the extinguishment of claims. is something which the IBBI and the government can consider implementing, maybe even through a change in the law. Moving on to Veena. Veena, my next question really is, given Mr. Bansal and Sachdeva have spoken about some of the practical issues that they are facing, could you throw some light upon, what are the legal challenges you have seen that stakeholders are facing in any restructuring or resolution process? And do you think that any changes need to be made in the law to deal with these distressed investments and to make them more conducive? And also just a add-on question is, have you also seen any unique structures that are being used by investors for investment in the stressed assets to get around or overcome some of the challenges?
Thanks, Aashit, and good afternoon, everyone. I think the biggest challenge in terms of just arriving at a resolution, especially in the pandemic and especially given the stress, for example, in the NBFC sector, has been this regulatory vacuum. You have the June 7th, you have the Companies Act restructuring, you have the ARC-led restructuring, you have IBC, which was suspended for a limited period of time. But there is still a resolution which takes place, outside of all of this without any formal framework. And that has some amount of challenges because in some ways, it is probably very efficient to arrive at a resolution through mutual negotiations, not really be bound by timelines determined by the court and things like that. But there is regulatory vacuum there, and that poses some challenges because it doesn't have the leeways or other benefits which has been extended if the resolution is being done under any of these other formal framework. The other challenge has been information asymmetry. Again, in the context of such kind of resolutions, there is a time gap which is there in terms of time crunch, which is there in terms of just how much information the resolution professional can provide, or for that matter, the company or a strategic committee which gets set up by the company can actually provide. And who takes responsibility for that action, right? I mean, if the promoter, if for the bank it is critical that there is a new shareholder who comes in, and that shareholder actually is the largest shareholder from a provisioning perspective, then who takes responsibility for the information that is being provided? So there is the information asymmetry has been a challenge. The other legal challenge that we have seen is that from a stakeholder's perspective, even within the same class, that there isn't a level playing field. Even through the entire alphabet soup of RBI's various restructuring regimes, there was always a feeling of a distinction between Indian creditors and foreign creditors. Now we are seeing that there is also not really the same platform being provided even amongst Indian creditors. For example, mutual funds as an investor had their own challenges in some of the NBFC resolutions. We see a lot of challenges coming in the context of secured and unsecured creditors, because if the creditor was vigilant enough to take a better security, at the time of giving the facility, within any of these means, while there is a line in the regulation which says that value of security has to be respected in some manner. On the ground reality, if I'm a 4% shareholder, a 4% creditor with a much better security, I would be outvoted and there would be a crackdown. There is also a socialist mindset to it that you need to look at resolution and not recovery. But again, that's not really how a creditor would approach it in a creditor-led resolution regime. I think the biggest challenge otherwise has been the litigation risk. Today, any investor who looks at India in the context of making any kind of a structured investment is always worried about, I'm willing to put in X amount of capital, I'm willing to put in, I'm willing to put a number to all the risks that anybody highlights to me. But what is the value that you give to litigation and the time that the litigation can take, right? So that's not an answer that any of us, even as experienced lawyers in this field, can ever give. And that poses some amount of challenge for sure. Moving to the other part of your question, Aashit, as to what has been the innovative structures, I think the most innovative structures have come through how the ARCs have taken this as an opportunity and provided for Section 9 resolutions under ARC regime. Especially with the suspension of IBC, there has been a lot of innovation which is possible, and it's not just pure conversion of debt into equity, right? It's more mutual. You have cooperation of the borrower to some extent. So especially in cases where it's a pure liquidity issue and you're not really dealing with a debtor who is otherwise tainted. We are seeing some good resolutions, and there has been, especially with foreign distressed funds, with the help of ARCs, and even otherwise, generally by just providing for that last mile funding, there have been some innovative solutions that have been provided, and those have been certain developments which have come out, especially with the suspension of IBC.
Thanks, Veena. That's very useful to understand. I think I just wanted to pick off on, you mentioned last mile financing as one of the things which you've seen. I think there has been, some amount of criticism, if I may say so, around, how the interim financing model works.
Yes.
In, the ARC, in the IBC system. And it's not really been very successful because of some of the drawbacks. Mr. Bansal, maybe if I could just ask you, what has been your experience on the interim financing model? Have you seen anything? I know you have, Edelweiss has been involved in certain interim financings or last mile financings, but do you see any challenges? And especially also given the pandemic, has that also sort of increased?
Okay, let me just go to first only one point, this pandemic issue and this IBC suspension. I think this keeps on coming again and again. I don't think IBC suspension has done anything, because even otherwise it was always suspended in animation, because there was no capacity of NCLTs. And let me also add here, this suspension was for defaults during pandemic period, right? So in any case, banking system doesn't go to IBC so soon that today you default and then tomorrow I will file an IBC application. And even if I file, the admission take 1 year minimum nowadays. So that was not bound to happen. In fact, the suspension created another problem. For the existing cases or with the old NPAs, all NCLTs presumed everything is suspended. So nobody really worked. Okay, so that was the real suspension. But I am sorry, I am not going there as of now. So you asked interim finance. So interim finance, I think we did a few cases initially, and we succeeded also. There were basically two challenges. One, there was a lack of clarity after liquidation order, the interest stops. Okay, so people were not very ready. Even I was not ready to take that risk that tomorrow liquidation order happened and my interest will stop. And when I will get the money, nobody knows after that, right? So, but even if I get within 6 months or 6 month interest, if I lose, my yield will go down. So that was the first challenge, which we spoke to IBBI, and they thankfully amended the guidelines and they made it 1 year now. After liquidation order, at least for 1 year, the interest is available now. The other challenge is sometimes, as I said, everything is a limbo. Like say, we provided, in fact, let me use a few names, I don't mind. We provided interim finance in Amtech as well as Castex. Now, where are those cases? Neither CIRP nor liquidation. Nothing is happening. And now 4 years are almost over. So, if somebody, we had to negotiate with RP. You pay some interest here, we will waive something. I mean, if that is the situation, if you reach, then there is no super priority which is supposed to be there. So that is another risk here. Now we provided interim finance at least in 10 cases, in fact. Some of them did work like Binani and all. But let's say in one case, big steel case, the RP wanted some 250 crore, but then committee COC didn't agree. So the other challenge in interim finance is the COC itself. Typically COC and RP views don't match. So COC is ready to provide finance only for CIRP expenses, but it's very difficult to convince COC to provide money for working capital or for the operations. The only thing which I think we could do it was in Binani, because we were the only lenders. In fact, we had almost 90% debt ourselves. But otherwise, COC feels, oh, why should we borrow at 16, 18, 20%? But they will not give themselves also, because they being a banker, that clarification is still not there that that can become standard asset. It is still classified as NP, unfortunately. Though it requires some clarification, perhaps RBI, somebody can take a different view also, but still they are not doing it. I think that is a challenge. So that is why one is COC, one is the interest rate, one is some of the lack of clarity after liquidation. These are the issues.
Right. No, I think that's very useful and very well said. I think this is an issue which people have been grappling with for a while. And I guess, the point you touched upon on the fact that, it's taking some time for cases to get resolved, and that has also been one of the grouses that the judicial infrastructure needs to be beefed up to, make sure that the resolutions happen in a quicker time frame, because the longer it takes to resolve, the more is the erosion of the asset value. So I think, very well said. And these are points which should seriously be considered. Just one point which we have been reading off late in the press is, a lot of concerns being raised on the haircuts that the lenders have been taking in CIRPs. And there is also some mention and talk about prescribing limits on haircuts. Because the general feeling is that banks who are taking 95% haircut and 90% haircut are really getting nothing in return, and bidders are getting assets at a cheaper value, and that is unfair for the banks and therefore unfair to the general public at large who has deposited money with banks. I just wanted to ask, Mr. Sachdeva and Mr. Bansal, what do you think about this? Is it prescribing a haircut? Do you think it's going to be feasible? Do you think it's going to have more an impact on the restructurings which you're seeing?
So let me just come in. There's a recent controversy or a decision which is now before the appellate court, etc., and the NCLAT. In the case of Videocon, Twinstar was the successful resolution applicant, and this decision was something where two banks now have gone and approached the NCLAT. In fact, their grievance was that the payment or the payment methodology which is being made under the resolution plan provides the payment to be made in a staggered manner, which means, according to them, this is contrary to the mandate of IBC, and also they raised an issue of haircut. Question is, from the legal precedents, and we have seen the Supreme Court approving many judgments, including the SR case, where they said COC decision is binding. Now it's the COC which will take a final view how much haircut. But the debate has started. Can there be a large haircut? And if there is a large haircut, whether something it will be purely left to the decision of COC, and then finally it will be approved by the NCLT looking at the decision made by COC. In the case of Videocon, this has come up as a where the challenge has been made. But we will have to wait for the final adjudication and final decision by the Supreme Court. According to me, let us look at a situation where there are large haircuts. Not only banks, but then there are other operational creditors who are also affected. Whether the interest of all the stakeholders will have to be seen, or whether you are only looking at the revival of the stressed asset. That aspect will have to be now examined more thoroughly or more minutely. And I think we will wait for the final outcome of the Supreme Court. In my view, till now, decision has been, if once COC has approved something, it becomes binding, and therefore the NCLT goes by the decision of the COC. So while Videocon case has raised certain doubts, we will have to await. I cannot make any more comments on that. I think Mr. Bansal can, with his own experience, can give his own views on that.
If I can add here, the whole talk is nonsense and humbug. Sorry to use these words, because the first resolution, by the way, in IBC, which was approved by NCLT, was our case. The haircut was 94%. First case, Synergy Dure. Nobody made any issue of that. Nobody talked about it. When I even wrote to Sahu Sahab also, I mean, he also didn't do anything because he also wanted to show it as a first success. Okay, fine, good enough. But let us understand why it happens, even in that case, why in Videocon or any other case. As I mentioned earlier, it's a question of value. Now, Videocon has been, of course, put up in a different way, which I don't want to go into case specific. But there is a 30,000 crore debt guaranteed by Videocon Industries for the oil fields. And these oil fields are not part of this resolution plan by the incident. Okay, so that's a separate company. Banks are still looking to resolve that case separately. And they will do perhaps good recovery. But when you add the corporate guarantee amount, in many cases it happens. Except Binani Cement, where even the full amount of corporate guarantee was also paid. There is not even a single other case in IBC history where you can get full payment against the unsecured loan also. Right? This was the second case called, let's say, Adoni, OMML, because Odisha Minerals and Mining, where they had 4 companies. So all 4 companies, debt was guaranteed by that company. What happens to Lanco, by the way? Lanco Infra is similar holding company, where there is hardly any business except EPC. But they had at least 10 to 12 power companies. And all the debt of those power companies was guaranteed by this company. Now, if you add all the debt and then calculate what I am going to recover, the figure will look 3-4% only, by the way. If at all you can get 3-4%. Now, the second point. Okay, fine. The point is well taken that I don't agree and we should not give such type of haircut. Then what? You mean to say what you will do? Is anybody going to compensate that? If there is no value, who is going to buy? So what you will do, you will go for liquidation. I have seen three shipyards. ABG, Bharti, which we have the debt, and third one is now Pipavav shipyard. All are like that, no? You have got a plan of 5-6% maximum. Everything is going into liquidation now because you will not accept those plans. Point well taken. Fine. But then what is the outcome of that? Is there just by talking or just by some media can make a big story out of this nonsense? It's not going to resolve the thing, no? If you don't accept 5% also, I am pretty sure when you go for liquidation, you will get 3%. So it's not going to help. You can make rules, but how you will follow those rules? Okay, let's say if we make a rule that we will not give haircut of more than 80%, fine. But if the value of the asset is 4%, who will compensate that 16%? Is government going to give that 16%? If government commits that much, I'm happily agreeing to haircut figures. It is good for us as a lender. I'll be happy.
Okay. No, I think that's very well said. I think the idea, ultimately of a CIRP and of a resolution is that the creditors and the resolution applicants must have the freedom to arrive at whatever mutually agreeable price. And ultimately, if there is value in a particular asset, a bidder will pay the value. But by prescribing,
I mean, this whole theory also presumes that these guys who are sitting in COC are fools and more intelligent people sitting outside.
Correct. Yeah, as you said, if you put such kind of limitations or conditions, it could just prove to be counterintuitive and ultimately will lead to liquidation of a lot of companies, which could ideally have been
looks good to make such statement politically, but there is no resolution of that. I'm only trying to say that.
Just to add, Aashit, when you are there on the resolution plan, you're looking for a stressed asset, you will always look into the value of the asset or the benefit which is going to come by acquiring that asset, maybe over a period of time. They have certain IPR, they have certain manufacturing facilities which are helpful to you or which will add on to your business. Those things have to be seen. Simply saying it's a large haircut, therefore this transaction should not be allowed, and those are being today, something which is being canvassed by the banks. Some of the banks who will become a dissenting financial creditor and they will try and approach the court, say, look, in our case also one of the banks, went up to the Supreme Court, but finally we got through at the NCLT level, at NCLAT, and finally Supreme Court. All those pleas were dismissed. But since in the Videocon, This issue has been raised and now being agitated. Finally, Supreme Court will have to take a view on the interpretation of what are the powers and ambit of COC and whether their decision will be binding and whether they have gone through each and every aspect. Forget about 94%. I think Mr. Bansal explained it. 94% or 90% or 80%, there can't be any yardstick. It depends upon COC's wisdom. And looking at the SR judgment and a couple of other judgments, it is left to the COC. Once they have examined this issue, I think there should not be any further debate on that.
Correct. You're absolutely right. You're absolutely right. I think by prescribing any kind of limit or threshold, you are going to curb the wisdom and the ability for the COC to actually reach a commercial bargain. So I completely
agree.
And
what are the options then? Is it revival of the stress asset, or are we pushing it to liquidation? And once it goes for liquidation, what is the value they are going to? Nothing. It will. So I believe particular aspect will have to be seen in the context of revival of the stressed asset. I think that is the paramount thing, rather than looking at the haircuts and how much money is going to be given. If that is a yardstick, then the operational creditors, look at a real estate company where stakes of operational creditors are much more than any other bank or lender. But L&T is normally, the operational creditor. Whether, they'll be paid that much money, answer is no. In the priority list, they will come much below. So by the time the money is paid to them, there is nothing which is left for them to be paid. So these issues have been seen in earlier judgments, and I believe revival has been the keystone or the paramount objective. And I think that will have to be again, reinforced by Supreme Court in one of the judgments.
I just wanted to add 2 points here. Sorry, interjecting. Initially, when we started IBC, there was a view that banks or COC cannot approve a plan if it is a below liquidation value. So slowly that view also got changed, and Supreme Court approved slowly plans below liquidation value. Why? Because it was clear that you are not getting that value. So that means there is some problem with the valuation, right? Now today what happens if there is a liquidation value? And I have seen, at least because we ourselves as an ARC, we went into IBC at least for 100 cases. Now, we have seen many cases COC didn't approve because it was below liquidation, right? All 100% cases, finally we got was in liquidation, we got less than that amount which we were getting through CIR. All 100% without fail. Except one, I think, exception may be there because steel industry started improving, we were getting slightly better in liquidation. But that was industry specific because industry started doing well. So my point is, COC is after all taking the view based on their loan amount, based on their interest. So they understand what is happening. And liquidation is going to give them less on later on. It is not going to give them. So I mean, and by the way, these 2-3 banks which went into courts, they are also only just to show to the public or just to show to the government that I am not agreeing to this. They are not serious. They also know it. Yep. They are also doing drama to show to the world that we are not agreeing. Finally, you have to agree. What is IBC then? If 66% is agreed, then who are you not agreeing? And why even NCLT or NCLAT is admitting their appeals? It's just a faltuka game, no? By lawyers and these people who just want to shoot the word. Otherwise, what NCLT and NCLAT has the power to agree to or even admit the appeal by these guys who are below 34%? But anyway, leave that. That's a separate issue. I don't want to say to Veena or ask to you also anything.
No, I think it's a fair point that you've raised, Mr. Bansal. I think the percolation of the Supreme Court's judgments down to the NCLAT, then the NCLT level, I think is still an issue, and the IBDI has.
But I am raising a basic issue that when 66% is agreed, the guy who is in 34%, what right he has got to go to appeal and the appeal is being admitted?
I think it boils down to the question of resolution versus recovery, right? The basic purpose of IBC has been resolution and not recovery, but when creditors approach it, they tend to think of it as recovery, though that becomes an integral part on how they vote or how they behave. Sorry, Aashit.
No worries. No, I think. So just moving on to my next question, really, and maybe Veena, if you can take a shot at this, and then Mr. Bansal, your views as well. We all know that the national ARC is around the corner. It's likely to be up and running in some time. The idea of putting together this national ARC or national bad bank is to improve returns on stressed assets, to probably increase the speed at which stressed assets can be resolved. Do you think that this will create more opportunities maybe for investors in stressed assets in India?
Personally, Aashit, I'm quite skeptical. And the reason I say that is because you have an established ARC regime today, right? It may have its own challenges to some extent, but what is it that a national level ARC is going to add? And how is it that it is going to distinguish itself in a sector which has seen a lot in the last 5 years? How is it that they are going to distinguish itself is something that that I'm a little skeptical about. This thing about everybody says let the banks put their bad assets into a separate entity, let them hive it off so that they can do what they're required to do, which is primarily lending and providing for capital in the industry and things like that. If the question is just of shifting the stress from one entity to another, then that's not really solving the problem, right? It may solve the problem to some extent and to some segment of the entire industry, but it's not really solving solving the problem itself. Will it create opportunities as such for distressed investments? I think to some extent, yes, it would, especially in the short run, it would. But I am not, at least personally, I'm not very sure as to how what would be the distinguishing factor of this ARC? How will it interplay with the existing ARCs, and therefore, how will competition look at it? Those are the two things that I kind of am wary about.
Thanks. Mr. Bansal, would you have any views around this?
Sorry. Yeah, I mean, it's a good thing, frankly speaking, if you ask me. Though it has that element what Veena is indirectly trying to say, that from one person to other person. But see, the problem here is this is too late. This NPA started happening in 2013-14. The AQR asset quality review of RBI happened in 2015. And after that phase, banks have hardly lent money to other projects. Corporate lending has been only going down. The banks or NBFC, they have been basically lending money to retail mainly. So why I'm trying to reach there is this cycle of NPA, which started, let's say, in 2011-12, has almost peaked or plateaued in 2015. So there are hardly any new NPA except a few, one Jet Airways and a few, like say NBFCs, DHFL or Altico or something like that. Otherwise, mostly these project-related assets, NPAs, which were in EPC, which were in power, which were in steel or textile, etc., all of these happened in 2014-15. So I'm just trying to reach somewhere. I am saying already banks have made enough provision in all this. Maybe 100%, because in 4 years you end up making 100% provision. 4 years, 3 months. Now, wherever you could find resolution where the assets were good, this has been done. And where they could not find a resolution, maybe some of them are going to liquidation, or some of them banks could not do anything. And now the list which is being, let's say, which is being circulating or whatever, which is going to the national ARC, it contains 50% of the cases, surprisingly, which are already in IBC, by the way. Now, what is the use of that then? That means IBC is not resolving those cases. Then what NARC will do? If the case is already in IBC, so why you are sending it to a NARC? That is my one objection of it. The second issue is the capital, 15%, which NARC will pay to the banks, is being paid by the banks themselves. So indirectly, you are converting your capital into a profit, because that will come back to the bank as sale price. Where 15% which they can make, which they are getting cash, they can book profit, I presume. So the third is the level playing field. They are asking other ARCs to bid in cash, while this ARC will bid in 1585. That means 15% cash and 85% security receipt, because 85% security receipt is guaranteed by the government. But of course, government has put a cap of 35,000 crore. So there are some issues, but as an ARC, I would say it's a good thing from ARC perspective. Why? Because the biggest advantage of NARCL will be the debt aggregation. Right. Because typically we face problem like, say, we buy from 10 banks, but the 2 banks stuck up and they don't sell. So, and the debt aggregation virtually takes 2-3 years for us. So now, when everybody is selling to NARCL, then we can buy the debt from NARCL or IDMC, which is the second company which they are talking about, debt management company. So the other advantage would be banks will be less worried in selling the cases now to NARCL, because they will not be worried about CVC, etc., etc. Because they do get worried otherwise while selling to ARC. And CVC has to some extent spoiled the whole thing about the ARC sale by putting a lot of conditions. So I feel that will be two advantages. One, debt aggregation. Second advantage will be the banks will be less worried about selling to NARC, because they're selling to their own company. So, see, the ARCs typically have 3 advantages over the banks or NBFCs. I'm just going to slide theory. One is the debt aggregation, which is happening already in NARCL. The second is the restructuring, which NARCL can do, I think, as compared to banks. Banks will not do restructuring of banking. And third is the fresh funding. Like, say, we have done as ARC, we have arranged funding in a number of cases, last mile funding, when you started the question. But banks don't do it because it becomes NP. So this is third question, which is not clear to me, whether NARCL or debt management company will be able to provide fresh funding. That question is still not clear to me. So I think if they can sort out that issue also and implement it in a better way, I think this should be a good success story. Depending on the asset quality, which are the assets by them. If you just sell them junk, then what they can also do.
True. So I think that's very interesting. I think very well said, Mr. Bansal. Just coming to the last segment really of this session, around pre-packs and the pre-packed insolvency regime. So as you all know, the new amendment to the IBC allows for pre-packed insolvencies. It's a variation from the normal CRP process. One of the changes is that under this regime, the debtor continues to remain in possession, unlike a CRP where the creditors are in possession. The creditors, of course, have the ability to change that and come into possession if the debtor is not cooperative. The debtor is also provided an opportunity to provide a resolution plan, which is not possible in many cases under the CRP process because of Section 29A. And if the lenders like the debtor's plan, then the debtor can initiate the pre-pack process. So it was thought about as being something which will work out faster, and the resolution can take place faster given that the debtor will be cooperating in the entire process. Currently, as we all know, it's available only for MSMEs, but we hope that this will also become available to large corporates at some point in time. So my question really is for the panelists and for all of you really. Do you believe that the current pre-pack regime is beneficial? And is it a viable alternative for resolution of stress in MSMEs? And are there any changes that you would suggest or make to make the regime more effective? Maybe we could start with Veena, Mr. Sachdeva, and Mr. Bansal.
Sure. I think as a product, pre-pack has obviously been a welcome change, right? I mean, when we look at what has been happening in other jurisdictions, generally as, just as an alternative, just as having the debtor in possession, having a plan which is with the buy-in of the current management, that has certainly been quite beneficial. I think one of the things that was mentioned in the ordinance which introduced pre-packs was that this is on account of the pandemic and this is specifically for MSMEs. So I think to that extent, it's very tailor-made in the approach. Any kind of regime, I mean, pre-pack as a principle is supposed to be not very formal, not very, yes, time-bound, because obviously that is the key measure for any kind of resolution in insolvency. But other than that, it is not supposed to be as formal as the CIRP process. I personally feel that the regime that has been set out now is quite prescriptive. It shouldn't have been that prescriptive. It hasn't seen, at least I have not personally seen much of the success with MSME in the pre-pack regime. The other thing is any kind of pre-pack in the way it has been formulated, right? Like if I have to have an RP, if I have to have consent of X number of stakeholders and the shareholders, etc., you have put up a process which is quite dependent on other other advisors, whether it is legal advisors, financial advisors, or just resolution advisors, right? Which obviously increases the cost of resolution. Again, that was not the purpose of pre-pack, and I don't know if it achieves that objective. So yes, certainly a required amendment, a noble amendment in that sense. But I think one thing that I certainly think which is required to make it more successful, make it more adaptable, especially if it has to be applied not just to MSMEs but to the entire corporate debtor world, then it has to be less prescriptive.
Thanks, Veena, for those thoughts. Mr. Sachdeva, would you have any thoughts on this?
Yeah, I tend to completely agree with Veena. She has beautifully summarized the pre-pack aspects. Looking at it, see, and I tend, why I'm saying so, the pre-pack, the way it has been designed, I think it should not be seen as a formal like CIP or something like time-bound. There has to be some kind of a, wisdom where it should be akin to private sale arrangement, something which is outside the IBC. And I think freedom should be there to look at a situation where pre-pack should be applied across the corporates, not only limited to MSME. Third, the issue which I think Veena also touched upon, when you are saying it is applied to corporate, will you be setting up the same kind of rules or norms like you have set up for the MSMEs, or it will be more on a broader base? How the aspect which is the regulatory, the stressed asset should come out of the purview of the stress, and somehow pre-pack benefit should be extended to them. I think that is my looking at the things. Mr. Bansal can further elucidate on this issue from his experience.
I'll prefer to avoid. I was just hearing the discussion before our panel. Ravi Kadamji was talking. So he made one point that Section 29A needs seriously have a review. If we can do that, all this drama of pre-pack should not be there actually. As of now, it has been implemented only for MSME. Frankly speaking, MSME don't need IBC. And nobody has gone, no lender normally goes to IBC for very small loans. They are settled to OTS system. I am only worried that this pre-pack thing only will be misused by collusion of creditors and the borrower, because they can get relief in statutory dues, indirectly, directly, whatever way. Though it says that if there is a hit to operational creditor, there will be Swiss challenge. So, but still, even after doing a Swiss challenge, very typically in these cases, nobody else will bid. So even if you do a Swiss challenge, these are very small assets where the default amount itself is fixed now. I mean, total is 1 crore. MSME debt itself will be low. There will be only 1 or 2 banks. I think they can resolve it outside the system, no? Why do you need it, as Veena said rightly, why do you need RP and all that drama, full-fledged system of CIRP? So it will be used only by those people, or I should just change the word, it will be only misused. So unless you agree to expand it to mid-corporate and large corporate, whereby it will really have some meaning, where indirectly then you are relaxing 29. Though I think government is not talking even today, even in this pre-pack, that they're relaxing. But for at least for MSME, they already agreed to relax. So I think somewhere we have to take this call that in mid-corporate and even the smaller large corporate, there is not great value. And you are not getting that value from a strategic interest. If there is no strategic interest, I think the better value can only be given by the existing borrowers of promoter. I think somewhere when we agree to this, perhaps as of now, it's politically, it is not being agreed. So at some point, we may have to agree slowly, government may extend it to mid-corporate and then large. Then it will have some meaning. Otherwise, for MSE, it will not work.
Fair enough. I think also, I don't think there has been, as Mr. Bansal said, it may not work. And I think there have been barely any cases, if at all, where MSMEs have really used this route to resolve their debt. I guess once the pre-pack model gets expanded to larger corporates, you may see a lot more activity there. But as Mr. Sachdeva said, I think in the larger corporate space, you may need some more flexibility. And as Veena said, you need to make the process less prescriptive than it already is to make it more successful. I think those are really the questions I had for the panel. And I just wanted to check, we have a few minutes left, if there have been any questions which have come up in the chat box. I don't know if anybody has, Prajakta, I don't know if there are any questions in the chat box, and we could take some of those questions up if there are any.
Just to add, Aashit, before we conclude,
Sure.
Whatever, and Veena will agree with me on a couple of points. See, the IBC, and when I'm saying so, I started with this, and I'll again conclude with that. When you take over a stressed asset, particularly with the understanding, and that has been captured in the resolution plan, also approved by the NCLT, etc., that for the prior period, there'll be no demands or litigation for which these stressed assets will be accountable after the takeover. What happens, same government, they allows to restart the old litigation, and they start issuing the demand notices. Now, what is the why we have section 238, section 31, all that 238 also talks about it has a primacy over the IBC laws, IBC Act has a primacy over other laws, etc. Given the fact these notices keep coming, now what is the alternative? One alternative I could think of, while the companies will keep approaching the high courts and keep asking for a stay order, etc. One of the issues I think we can look, and whatever the pending litigations are there as of date of resolution, which is getting approved by the NCLT. NCLT should, look into those litigations minutely. After all, it's a judicial forum, and say these litigations will no longer be applicable against the stressed asset post-acquisition. Demand notices or the various pending demands which are being enforced against which are going to be enforced against the stressed assets, those should be no longer be applicable, and those should be somehow the NCLT should say in so many words. I think that is the only way we can get rid of this problem. Otherwise, you see today the number of litigations which the companies have, the successful resolution applicants are filing after they have taken over the stressed asset under the IBC is another additional cost, which I think somewhere has to be avoided. Unless Veena, you and I would like you, because you are on the practicing on this side, I would sincerely request your views on this panel and how it has to be dealt with.
No, I agree with you. That's the only way it can get evolved, right? Because if you look at anything which becomes and the IBC generally has seen 5 years now. So if it has served the immediate need at that point of time, and as a regulator, IBBI has obviously been very, very active, especially with something like pre-pack, where we have the opportunity to do something different. And look at the other countries which have adopted it, right? I mean, at the end of the day, stress has been everywhere. We are coming out of a pandemic where stress is going to continue. It's easier to, it's like the sandbox system, right? Like the regulatory sandbox system. You allow something to grow before you make it very prescriptive, so that you learn from at least the experience of people who are going through it, rather than providing for something which people are not going to use at all.
Thanks, I think. Thanks, Veena, on that.